Medicaid allows a spouse, an at-home spouse that we call a community spouse, to retain $113,600 of assets and still have their spouse qualify for Medicaid benefits. So if the transfer that you're talking about will not cause that spouse's own assets to exceed $113,600, then absolutely transferring those assets to that spouse would be a wise thing to do. If, however, the transfer of those assets will cause her assets or his assets to exceed $113,600, then transferring them will not cause qualification, nor will it hinder qualification, regardless of whether those assets are held by the applicant or held by the applicant's at-home spouse. The joint assets of the husband and wife still exceed the Medicaid limits, and therefore the person would not qualify for Medicaid benefits until something else were done with those assets. There are certain other exempt assets that also should be considered to be transferred to the spouse. For instance, the home. If the home is owned by the applicant, it's an exempt resource, but if the applicant dies owning that asset, then Medicaid has a lien against it. If instead the home is transferred to the spouse, it's still an exempt resource, but if the applicant later dies, that house is not in that applicant's estate and therefore would escape any type of Medicaid recapture from that person's estate. So there are certainly planning opportunities available between spouses. Transfers between spouses do not result in penalty. And so the penalty that we talk about in transferring an asset within the last 60 months do not apply between spouses. And the reason for that's very simple, because we count the assets of both husband and wife toward Medicaid eligibility. And so transferring from one to another, with that small exception of that community spouse resource allowance of $113,600, will not change the eligibility equation, regardless of which spouse owns the assets.